Greetings, everybody. This is Brian Tarian and Carl Osterhout here with you today. Carl, thanks for joining.
Thank you, Brian.
Yes, so I convinced Carl to spend a few minutes with me today because I see a trend of situations where individuals prepare for their Social Security disability hearing, which could be up to 3 years, and they go to their hearing and they're not successful. And there's some common pitfalls that happen here. So, the resident expert, there is nobody I know that is more qualified to speak on this topic than Carl, because Carl, as of a few years ago, my data's old, handled over 25,000 Social Security disability cases. But we rely on you in these situations to see, what has gone on with the case at the hearing, if the judge made a mistake, or if there's a chance for appeal. So you know this stuff really well. So thank you, thank you, thank you for taking a few minutes. Um, so for today's agenda, we're going to go over some examples of actual cases. I have stripped out all the personal details, so they're generic, and we'll go through some examples of what was actually happened to people. And then we can kind of go through in a general format what you could do if you're denied at a hearing, what your options are. Should you appeal, should you not appeal? We can talk generally about that. And then if you need some help with your case and want to have your case looked at, we can give you directions for that. Okay, so that's enough from me. So, Carl, in advance of going through some of these examples that we have here, folks, and I'm just scrolling down through the screen here, I'm going to start going through some of the examples. Is there anything in advance that you'd like to set this up with before we get into case by case examples?
Yeah, I think that the thing that's helpful to remind, and we may have discussed this on another in another conversation, but I think it's always important, and certainly when we're trying to explain our own decisions or not to appeal to our own clients. These are people, of course, that we've worked with closely in many cases for a couple of years up to that point. Um, and so we're feeling the disappointment along with them. Um, the thing to keep in mind is that once the ALJ Social Security judge denies the case, an appeal to the appeals council and ultimately to federal court, which I think we'll be focusing on today, the issue is very different at that point. In a strange kind of way, at the appeals council and in federal court, the issue isn't even all that much about whether the claimant's disabled or not anymore, like it was at the ALJ level. And what I mean by that is this, is that when your case goes to the appeals council and to federal court, then these are appellate courts. And appellate courts review decisions that are made by fact-finding courts. And they basically have two things that they're looking for. One is for any legal errors, and second, for factual errors. Now, it gets a little complicated because sometimes it's sort of both in the same argument, a legal and a factual error. But to try and keep it somewhat clear, uh, a court, an appeals court like the appeals council or the federal courts, is not looking at the record to determine whether the claimant's disabled. They are looking at the record to determine whether uh, substantial evidence supports the ALJ's decision to say that the claimant was not disabled, and that's very different. And basically what substantial evidence means is kind of the opposite of what it sounds like. What it really means is that if two reasonable people could disagree about whether or not this person's factual setting supports a finding of disability, then the appeals court's job is to defer to the Social Security judge and say that there's no error here that we can review. So bottom line is, as I'm sure all of us know, even if we find it hard to admit in a certain circumstance, uh, two reasonable people can disagree about a lot of things. And so this is the backdrop, really, of all the decisions, almost all, I should say, of the decisions that we have to make whether or not to appeal a case that's been denied by a judge. Because our burden in the appeal is going to be to show that the Social Security judge's decision that no reasonable judge could have arrived at that outcome.
Okay. Is there a classic example that you could share?
Well, a classic example, let's say a common example, and this gets us into some of these examples that you asked me to look at before today.
Mm-hmm.
In many of these cases, it is quite possible that everything the claimant said was absolutely accurate and true and etc. But in many of these cases, for instance, no doctor actually confirmed with an opinion that the claimant's limitations were reasonably consistent with the medical conditions that they had.
Mm-hmm.
And in fact, in some of these cases, quite the opposite. The agency's examining doctor found that the claimant certainly had medical conditions and certainly had limitations, but did not have significant enough limitations to conclude that there was no kind of job that they could do. Many of these cases in our example list, for instance, just did not have a treating source statement from a doctor in support of the claimant's case. Now, that's not sort of the be-all and end-all exactly, but it's a really big deal when you don't have that, because then you know the agency's doctors 90% of the time usually find that the claimant's got some ability to do some kind of work.
Mm-hmm. Yeah,
so you're swimming upstream right from the beginning.
Yeah, they're good at that. So tip number one is get doctor support. Do the best you can to get it. Not all doctors provide it. Right?
Yeah, absolutely. I mean, it's easy to say for sure, and harder to do sometimes.
Mm-hmm.
But clearly, for this type of case, where basically the issue is the claimant says they're disabled, the ALJ says they're not, and it's just about the level of work that the claimant can do, that will make it very, very difficult in most cases to proceed with an appeal. The other thing I'd add here is that most of your examples are younger claimants.
Yes.
And so the fact that they're younger means that basically we get no advantage in terms of the agency's medical vocational rules, and we don't get to, and so we end up with a burden in every one of those cases that the claimant had to show that there's literally no work at no exertional level that they can perform. So it's basically the toughest kind of case to make.
Mm-hmm.
So when you have the toughest kind of case to make, and there just isn't medical opinion support for a finding of disability, I would say 90+% of the time that pretty much answers the question of whether or not to appeal the case all on its own.
Okay. So, flipping it, if there's doctor's support and in the file, that is a go-to point that would be, that you could start with to appeal.
That's correct.
Okay. Good. All right, that is very helpful to know. So what I hear you saying, Carl, is yeah, these are under 50s, under 50-year-old individuals, and for those of you out there listening that are not aware of this, and if you're under 50, you need to prove that you're not able to do any job in the U.S. economic system, like not the work that you were doing before necessarily, but a greeter at Walmart or a ticket taker at a movie theater. So these are more difficult than somebody that's over 50, right, Carl? You know this part better than I, where you have other variables in there where you could potentially work on proving that they're not able to do the type of work that they did before. Am I correct?
Right. Yeah. Essentially, the law starts to bend the claimant's way at age 50 and then even more at age 55. And really what it comes down to is that Social Security has you can't teach an old dog new tricks rule. And at the inability to perform work you've done in the past isn't always the whole game, but it's a lot of the game. And if you can get past that in a lot of these cases, then all of a sudden a lot of possibilities open up in terms of appealing the case to the appeals council or to district court.
Okay. Okay, great. So let's take a look at some of these examples. Example number one, a 42-year-old that has degenerative disc disease, diabetes, neuropathy, other impairments, and there was no appeal recommended. Now, this is very basic information. What could you share with our listeners out there with somebody that's got these conditions, and why there would have been no appeal?
Well, the first thing I'd say right off the bat is that it's not so much about what medical conditions they have. We have very few cases where there's really any dispute about that part of it. Here, this is just a classic example of what we were just talking about. Claimant's younger. They clearly have several medical conditions that even the ALJ agrees that they have. The ALJ found that they could perform a light type of job, which is being on your feet and not lifting a whole lot of weight. But even if the record supported a lower exertion level, like let's say sedentary, where you get to sit most of the day and hardly lift anything, because of the claimant's age, they still wouldn't entitled to benefits. So without a treating source statement in this case, and in fact in this case I don't think there was even a Social Security medical exam. Essentially the only medical opinion evidence in the record were the opinions of the agency's non-examining doctors that review the file. So there really, for lack of a better way of putting it, there really weren't any bullets to shoot.
Okay. So no doctor support, no agency exam. Okay. This one's a little closer to 50, Carl. 49,
Yes.
49 and a half. So is there anything that stood out in this that would be helpful for our audience to know?
I either am imagining it or I actually vaguely remember this one. But it's very typical of another kind of situation, which is much, much closer in terms of appealability. And the reason was because of the claimant's age. In a lot of cases, the judge is making a decision within 6 months of an age change. In this case, the claimant was going to turn 50 in about 7 months, a little bit more than 6 months actually, after the decision. So sometimes what we can argue in a case like that is what's called a borderline age argument, where we can take advantage of the regulations and other rules that the agency has that says that if the claimant's really close to an age change, the judge has to take that into account when making a decision. However, here the real problem in the end was that this was a case where the claimant actually had a treating source statement, but the treating source statement was, in a lot of ways, the knife in the back of the whole thing, because the claimant's doctor in this case released the claimant back to full duty. And so that's really a problem. So just as much as that not having one at all is a problem, having one where the claimant's own doctor is saying that the claimant can do some level of work, I mean, that's practically a no-brainer, no. Not always. You know, we're kind of talking simplistic examples here, but this is clearly a problem. There are errors in this decision, and it points out another problem, which is that the mere fact that the ALJ made an error, okay, in this case, the error was that he did not consider the closeness of the claimant's age change. However, those errors have to be harmful. They have to matter. And in this case, because of the claimant's type of work that they had performed in the past, combined with this really hurtful treating source statement, what was likely to happen in this case is an acknowledgement by the court that there were mistakes made, but that in the end it did not change the outcome of the case. Mm-hmm. And so this is really a nice example of a case that was like inches away from being a reasonably solid appeals case. But you know, we live in an age when we have to submit everything to the agency now. This is not a blame thing. This report from the doctor obviously existed, and whoever handled this case for the claimant, or if the claimant had handled it on their own, either way, they had an absolute obligation under the new rules to submit it. So it kind of just is what it is.
Mm-hmm. Yeah. That's what you call a deal killer.
Exactly.
Yep. All right. Now, if some of these are very similar, we can just skip them. Give a general idea if these are.
I'm sorry. Number 3 is an amalgam of what we've just been talking about.
Okay. All right. So let's take a look at 4. Younger individual, 44, fibromyalgia, chronic pain. RFC, sedentary, no overhead reach. Anything different in this one?
This is a case where it was another case that was tempting, and the reason was that the judge's own findings were very, very restrictive. And we had internal conversations here in the office about it because it looked like it might have been possible to sort of thread a needle on this one, because when you combined all the different limitations that the judge set forth in the residual functional capacity finding, and we went to the vocational source materials, there was a way you could have possibly argued that this combination of limitations ruled out the types of jobs that the judge relied upon to deny benefits. So here, there was technically an argument, but in this case, which I had to go and look because I wanted to make sure I was right about this. This was a case out of what's called the Sixth Circuit Court of Appeals, and that includes Ohio, Kentucky, Tennessee, and Michigan. And unfortunately, in the Sixth Circuit, the type of argument that we were thinking of making in this case will not be entertained. It is not unusual at all in some of these cases involving complicated regulations for some circuit courts of appeals, some areas of the country. Certain kinds of arguments work and others don't, to put it simply. And here, basically what the Sixth Circuit has said is that the kind of challenge that we would have preferred to mount in this case about the combined effect of the vocational limitations has to be made at the hearing level, or it's waived.
Okay, so if it's that puts the attorney in an interesting position. I mean, they really need to understand the higher level nuances of an appeal going in, or
Brian, I could fill up your webpage with the audio on this topic. I've talked about it hundreds of times. It's one of my biggest gripes about how cases are handled at the administrative level. This is a very, very important area of the law and of the practice, and this isn't just theoretical. This is like day-to-day, down and dirty, right in front of the vocational expert at the hearing stuff that in most of the country, there are a few circuit courts of appeals where you can raise these issues at the appeals level, but by and large, and you can't even count on that. Even in the circuits where you can make the argument, sometimes they just don't pay attention to that, and they find against you anyway. I mean, there's a very high premium placed on issues, especially something like an issue with what a witness said, vocational expert in this case, in addressing it right then and there at the hearing. It requires an incredible amount of work. I always preface my presentations to folks by saying that I'm never coming in to talk about how to make it easier for people. Mm-hmm. This is a very complicated area of the practice that, to be blunt about it, most practitioners haven't bothered to really get into and understand it. Mm-hmm. Mm-hmm. Now, I don't say that judgmentally. For probably the first 20 years of my career, I didn't have to know this stuff because I just was very fortunate to practice in an area where the decisions were largely favorable and the vocational experts were pretty agreeable folks. But over the course of the last 8 years, when things have become more difficult and Social Security has changed some of their rules, I think in many cases very to hold the judges to making correct decisions, I had to go back to school essentially when I was 50 years old to really learn a bunch of stuff that I didn't have to know most of my career. Mm-hmm. It's very technical sometimes and complicated, yet there are some at least basic things that could be done in every case to give the claimant an advantage on appeal. Mm-hmm.
Mm-hmm. Well, that's very interesting to know. I've learned several things today. Okay. I think the last example here is, oh no, this is, I think 30 may be similar to others. I'll let you, well, no, or I say 30. This is a number 5, I'm sorry. 30-year-old. Yeah.
I know what you're saying. Yeah. This is not much different than the other cases, except for it's another example of where there were mistakes in the judge's decision, but because of the claimant's young age and lack of an opinion that supported disability, mm-hmm. We just didn't see an opening. Mm-hmm. Mm-hmm. The last one on the list is a classic example of something that drives me nuts, which is that, now look, sometimes let's get into the hearing and the truth breaks out and, life goes on. In this case, my belief about this case is that the claimant was kind of hard to handle, had their own ideas about what they needed to say in the hearing, and of course they were wrong. And so in this case, there was a treating source statement, but the claimant's testimony was less favorable than the treating source statement. Mm-hmm. Now, mm-hmm. I'm only guessing, reading between the lines, but so I'm not going to say in this case I know for sure what happened, but it does point out something that I think is important, which is that claimants have to I should say, representatives have to take control of the situation. In most cases, they know more, even if they don't know much, to be honest with you, they know more than the claimant does. And some things just aren't helpful. And I spend a lot of time prepping clients. We prep the client all the way through the case using what we call a roadmap, where we're trying to keep them on 2 or 3 topics. Some people's cases are very complicated, but most cases really aren't when it comes down to it. And so what we try to do is keep the claimant, blinders on the claimant, and stop them as much as we can from talking about or thinking about things that aren't going to help their case, and only on things that will. I call this the Alamo, all right, that there's 1 or 2 or 3 things in a case that you know for a fact, if you prove them or convince the judge of them, that you will win. That doesn't mean you always will, but if you've got the claimant on the same page with you at the Alamo, you've got a much better chance of being successful, because now the claimant's been prepped, well ahead of time, to understand what's important and what is not about their case. Mm-hmm. Not the claimant. Their lives are very chaotic and sometimes unhappy and maybe even miserable. You expect them to do this. So, I'm not necessarily saying I know what happened on this case, but I suspect it. And even if I'm wrong about this case, it's a very important thing to know or to practice in representing people in these cases, or preparing them for hearings, or in preparing new applications for benefits for folks like some of your advocates do, to keep the claimant on point. Mm-hmm. And on the main things that will win their case if proven.
Mm-hmm. So for those of you listening out there, the main point that this claimant made to the judge is that she doesn't work because it's hard to find a job, and that's not consistent with Social Security regulations, and that her impairments, her mental impairments, are well controlled when she takes her meds. So those 2 statements did not help her at all. One other thing, reflecting back on these examples, Carl, that I'd like to get you to comment on. Somebody's going through the approval process to get to a hearing, and as we know, it takes a while. And some of the oftentimes we see treatment is sporadic because of financial resources. What can you say to those out there that are going through this? I don't need to explain this in detail to you. I'm sure you see it all the time. They can't afford their treatment or whatever the reason is. But when they get up to see the judge wants to see that everything's treated consistently and it's not getting better.
Well, fundamentally, okay, if the claimant cannot get treatment because of financial reasons, a lack of free medical care or low-cost medical care nearby, either it's because of transportation issue or literally a no-money issue, something like that. These are definitely reasonable excuses to not be able to document a case. But what people skip the step all the time. Representatives, it's not again, most of this stuff is not the claimant's fault. How would they know? People skip the step all the time of actually demonstrating that. If the claimant lives in a county with no free medical clinic, you have to at least give the judge some reason to believe that that's true. However, most places do have at least one, and the claimant has to document somehow that they're either on a waiting list or that they've tried to call. This can't just be brought up sort of willy-nilly at the hearing, like the judge just has to believe whatever the claimant says. Mm-hmm. Whatever can be done to document that, let's say, mental health treatment is not available at the free clinic in Podunk County, whatever can be done to demonstrate these things needs to be done, because under the ruling that's appropriate here, the ALJ absolutely does have to take into account the claimant's inability to get treatment, but the claimant has to demonstrate that low-cost or free care is not available. Now, it's sort of like proving a negative. It can be tricky figuring out how to do that, but the attempt at least has to be made.
Okay.
Now, once that's established, at some level, the judge has to pay attention to it. Well, now we're in a whole new world, because the Social Security ALJs absolutely have the obligation to be curious about the claimant's medical conditions, and if the claimant can't document them because of reasons like this, then the judge has obligations to help the claimant document them, usually by ordering medical examinations, consultative examinations, and the like. And that can be a very strong issue in court. One thing that I've noticed over the years is that district courts don't like don't like it when ALJs just don't give the claimant the time of day in this kind of situation. It's very consistently the case that courts will hold the judge's feet to the fire on this if you give them an evidentiary basis to base a decision on. Mm-hmm. But so often, it just sort of comes up sort of willy-nilly at the hearing, and there's been no strategy about this at all, no attempt to document these things that we're talking about. And so, again, a judge isn't absolutely obligated to believe everything that the claimant says. You have to prove these things as best as you can. You have at least try.
Okay. Well, this is good news. I mean, there's so many people that we've come across that have treatment challenges for those either geographic, financial reasons. So, yeah, thanks.
Oh, one of the things I feel most strongly about it, and when we run into this issue, even at the appeals level, I'll do everything I can to turn over those stones if I can for the claimant, because I just think it's so fundamental to the judge's job that they can't just look the other way when this situation presents itself.
Mm-hmm. 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 Awesome. Okay, so next, Carl, as we cover a few more points and then wrap up here today, what I would like to do is go through kind of the workflow, if you will, of what somebody's options are if they go to court and they're denied. As we know, they can appeal in that process. So here's my take, and I'll see if you can kind of backfill it a little bit for anything I might have missed or correct me. If you go to court, have a hearing in front of an ALJ, and you're denied, you have the right to appeal. It's in your denial letter, and that's called the Appeals Council, right? Case like that we went through here today are examples of these cases that were denied at court. So what we do here at the Disability Digest is we have our members go to our resident expert Carl and his team, and they decide if that should be appealed. Now, if it can be appealed, then can you speak to like what the time frame is for decisions, what the percentages are? Is there anything that you can share with the kind of the probability and expectations for time?
Yes, and actually that reminds me of something I meant to say, that one of the reasons why it's important to be appropriately tough, let's just say, in these appeals cases that you send to us, is that once the claimant appeals to the Appeals Council, the rules changed 3 or 4 years ago to say that if the claimant appeals to the Appeals Council, they cannot file a new application until after the appeals council makes its decision. Back in the old days, you could do both.
Mm-hmm.
Now, you have to pick one or the other. And so this time thing is really a big deal, because once you've made the commitment to the appeals council level of review, that is going to take, on average, I would say it takes about 6 to 8 months. But there are lots of outliers. And so some of these appeals council decisions come back very fast, like within a month or two, very fast relatively speaking, within a month or two. And it's, on the other hand, however, it's not unusual at all for an appeals council decision to take over a year. And so that whole time, the claimant cannot get started on a new application, cannot get the wheels turning, maybe to just get a better outcome with better evidence or different evidence the next time. So this is why we always try to keep that in mind in terms of whether or not we're going to tell a claimant essentially to forego the ability to go right back into the line and file a new claim for benefits.
Mm-hmm. Okay.
Just that the judgment has been made, that the appeal is appropriate, and the appeals council level, like I said, is going to average about 6 to 8 months.
So one thing that I'm just thinking of here, Carl, is if, let's say, somebody has they go through an appeal and they have a date of last insured, meaning their disability benefits are in essence going to expire in 6 months, and they go and they file an appeals council, that's their last shot if this decision takes more than 6 months, right? Because they become uninsured.
No, that's actually not right.
That's not right?
No, I'm being blunt in responding to that only because it's a very common misconception, and I want to disavow everybody out there in Disability Digest land of that immediately. All right, the date last insured issue is only a problem if the Social Security judges, if the ALJ's decision is made after the date last insured. So let's say, sake of argument, the claimant's date last insured is June 30 of the given year, and the Social Security judge makes a decision on July 1, next day. The claimant is not disabled. Essentially, then, that ALJ has decided the claimant's Title II claim for once and for all, unless that case is successfully appealed. But let's use your example. If the claimant is, or if the date last insured is still June 30, but the ALJ denied the case on June 1, then a subsequent claim could still be filed on the issue of whether the claimant's disability could be established sometime in that 30-day period between the judge's decision and the date last insured.
Okay, so
it wouldn't matter at all when you filed that application. It could have been, you could be the next day or 2 years from the next day. The claimant would always still have that issue.
I want to make sure I get this. So you're saying that even though their date of last insured is, we're using, what we say, June 30th?
Yes.
If their date of last insured is June 30th and they don't receive a decision on their appeals council appeal until July 30th, and it's not favorable, that they could then in August, September, October, any time in the future, they could start a new application?
Yes, because the judge is the fact finder. All the appeals council is doing when it says no is saying that we don't see any basis to disturb the decision that the judge made. They do not make factual findings, except for in very, very rare cases, maybe 1% of the cases. So that nothing that happens after the ALJ's decision, 99.9% of the time, is going to affect the claimant's ability to go back and apply for Title II benefits again based on that date last insured.
Is there
The
any?
only
Is there any time restriction on it, Carl?
Nope. Look, and if you stop and think about it, you actually know why. Because we've all had cases where the claimant comes in and their date last insured was 5 years ago.
Mm-hmm.
And that intervening amount of time has absolutely nothing to do with whether they can file a Title II claim.
Okay, and I'm going to ask why.
Because there's no time limit on when you can apply for benefits. If the claimant's date last insured is long ago in the past, I won a case one time where the claimant's date last insured was in 1964, and it was in the 90s when I did that.
Okay.
There's no time limit on when you can apply for benefits. The only problem is when the judge's decision, the ALJ's decision, occurs after the date last insured has expired. That's a problem. That's a case that if there is any possible way to appeal it, it should be appealed, because that is now a situation where the claimant's ability to apply for those benefits could be they could be prevented essentially forever from ever applying for those benefits again. But the reason isn't because of when they file. The reason is because the judge's decision, unless successfully appealed, is the final decision. And since the date last insured was before that date, that means that the ALJ decided everything there was to decide about whether the claimant was disabled on or before their date last insured.
Mm-hmm. Mm-hmm. Wow. I've been doing this for 15 years, and I didn't know this. Yeah. Yeah.
Well, if it makes you feel any better, that's why I spoke. I mean, I thought it was a great question, and I'm mad at myself for not thinking of it myself, because it's a very common misconception, and cases are appealed incorrectly, or worse, not appealed based on a mistaken understanding of how all of that works.
Mm-hmm.
You could, again, almost everything we've talked about could be the subject of one of your short programs, because they can be tricky.
Sure.
And I almost regret that we're, trying to stuff this in at the end, when both of us know that, the time of this conference is already a lot longer than you normally would put on your website.
Yeah. So it's great. Okay. So we've talked about somebody goes through and they, if the case is accepted, what the time frame is. If the case is not accepted at the appeals level, then somebody can apply for again. And start a new application. Now, I'm going to go through, and as I did before, correct me if I'm wrong. If somebody starts a new application, and I'll use June 30th was the denial, and they start a new application in August, the new application and what needs to be proved is that there is evidence after the June 30th decision that supports the fact that they qualify for disability. Is that correct?
That's right.
Okay. So if somebody is out there listening and they're thinking of applying again, and they want to go back into the time frame that the judge has already decided on, you do not have the ability to do that. So you apply going forward. So ideally, if you don't have doctor's support in your application, in the prior one that got denied, of course, get it in the new one and do everything else right. So anything to add to that, Carl?
No, I don't think so. I think that this is, again, one of the reasons why, or I should say it's one of the things that we always have in the back of our mind. Like it's not, we wouldn't recommend an appeal on a case just to prove a point or something like that if it's going to foreclose the claimant's ability for God knows how long to get a new application filed. That's not how we would treat our own clients, and that's not how we would review any cases that are sent to us to review by a referral source like you guys.
Mm-hmm. 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 Okay. Great. Great. So just a few things I want to cover in wrapping up here today, and then we can explain how folks can get some help with their individual case, is that if a case has gone to court and got denied and you're looking at an appeal, you're either trying to pinpoint a legal error or some type of factual error, right? To determine if it's possible, okay? The other key thing here that I've heard from you is doing whatever you can to get your doctor to support your disability claim. There's forms called residual functional capacity reports that are super easy for doctors to fill out. Have something like that in there. So those are a few key things that I heard, and if you're not able to get your treatment for whatever reason, have that documented. So those are the highlights for today. So if you are listening to this, for example, out on YouTube, and you want to get some help with your case and have it reviewed, there will be a link below. If you're watching the video and you're actually on our webpage, there is a green button that you can click on and fill out the form, and we can put you in touch with somebody that can help you go through, review your case, help you understand your options moving forward. So, Carl, thank you very much for this information. This has been fantastic. I mean, if somebody's going through the disability process and they just take 27 minutes or whatever it is to listen to this, it's going to save them a lot of angst. So I really appreciate you taking the time today for our members out there. So and we'll come back, maybe have you back and spend some more time and cover some other topics.
I would love to do that. Thank you for a chance to do it today, and I hope it helps.
Fantastic.